Today we have a meeting with Янносом Георгиадисом. We know each other for quite a long time, and when in Вестника Кипра group we had a suggestion that maybe I could arrange a meeting with Yiannos, I thought, why not? I messaged him, and he immediately said yes. He was willingly wishing to explain his point of view and to give us some more details. There are two facts. Fact number one: Yiannos was the only lawyer who was fighting against illegal decisions all the way. And after he published an open letter, an article in Cyprus Mail, hundreds of people started to contact Yiannos and ask him whether he can represent them in the court, and he did. And Yiannos, when did you submit the case regarding the parents and children and these tests in the schools?
The case for the children, I filed it just before Easter. It was relatively very recently I did that.
Can you tell us the story about this case? Let's start with this case. So in Cyprus, we had a demand that all children in Lyceum, in the high school, should have tests on a weekly basis. And at the beginning, ministry said that these children may choose whether to have tests or not. And if they do not have tests, they can continue studying online. But Ministry of Education announced that no, it's not possible. And those who do not come physically to school, they will just miss the lessons because the school cannot provide both physical lesson and online lesson. So a lot of parents were upset because in a way that was pushing them for the tests, and quite often tests. So what was the situation they described to you, and why you decided to go to court?
Okay, it's true what you said. I mean, it was not
Oh, sorry, Yiannos, I want to, sorry, so we lost your sound. Can you unmute yourself?
Yes.
Yes, okay, so.
Yes, I was saying that is quite true what you just said. Initially, there were not, it was not mandatory for the kids to do the rapid test, and that was for a long time during the COVID period the case. But then they decided suddenly to change this and made it mandatory without even discussing this with the parents. And this had triggered a reaction, obviously, by a lot of children and a lot of parents who wanted to know their rights. So they came to me and asked my opinion. And I told them that this it's against human rights, and it is also unconstitutional. But above all, it's unlawful because after studying the law, I realized that all these decrees, they should pass through the parliament, but they have never passed through the parliament. This is provided by our constitution also. But if I may explain to you, as it is our law now, we have the so-called infectious disease law. We inherited from the UK, since we used to be colony, and we inherited the English common law in Cyprus. So this law provides in Article 6 that the Council of Ministers has the power to issue any regulations for the purpose of this law in order to deal and protect public health. But there is another law which provides that any authorities given to the Council of Ministers by any law of the Republic to issue regulations, the Council of Ministers must file it with the Parliament, and the Parliament must approve it first before it is valid, before they are valid, these regulations. And in this case, they have not done so. It circulated in the media at some point that the House of Representatives authorized the minister to issue decrees without them being filed with the House of Representatives, but there's not such a thing. I think it was just false information, in my opinion, because there is nothing changed in the law. The law, it is as it was, and therefore, any decrees issued without the approval by the Parliament, they are unlawful.
Okay, can I stop you right here and just summarize? So we will start with the fact that we do not discuss now whether the measure is correct or not. We can start with the fact discussing that the minister does not have right to have such decrees without approval of the parliament. So whatever he decides under normal circumstances, without any exceptions, should go first to the parliament,
Yes.
being approved, and only this, after this, can be introduced to the public, correct?
Exactly.
That's number one. Mm-hmm.
And there is also another way, of course, I must say, so people know, there's another way that the minister could probably, or the Council of Ministers could issue decrees. There is a provision in our Constitution, it's Article 183, that it provides that the Council of Ministers can declare the state in a situation of emergency. This has not been done, as we know. But under Article 183, in these extreme situations like wars, the Council of Ministers can declare the country at the state of emergency. But this also has to pass through the Parliament, through the House of Representatives, and it only lasts for 2 months unless the Parliament extends the time. So, on one hand, the state was not declared a state of emergency, the country, and on the other hand, the existing laws that give the power to the executive, to the government, to make restrictions was not followed. So we are now having in place some decrees that they are unlawful, and the people are charged on this. They are fined on this. And I don't know, I believe when people go to court and they raise this issue, I'm with the opinion that they will not be able to, the prosecution will not be able to prove their case against the persons who didn't wear masks or they didn't follow the decree of the minister.
All right, that's number one. And when you gathered the information from these parents and you applied, what were you against I mean, what did you write as a description of the case? What you brought to the court?
Okay, first I would like to say to you that we didn't rush to the court immediately. This is important. We made a very detailed letter because our goal was not just to go to court. Our goal was to solve the problem without the need of litigation. But that's why we prepared a very detailed letter outlining the law, explaining why we believe this is wrong, and also saying that in any event, these measures, they are against the human rights, against the constitutional rights, they are disproportionate, and they don't serve any purpose. And also, it causes a lot of disturbance to the education of the children. It infringes their human rights. It influences their mental state, especially those who want to exercise this right. And because there were a lot of matters that they came to our attention that either headmasters or teachers were they were not very careful as to how to handle the children. They were sort of threatening them that they would lose their gear, that they would not, it would be bad for them. They were labeling them and they were discriminating against them. And something that is not supposed to be done by these people, and it's against the law also. So we outline all these things to the relevant bodies in the government. Unfortunately, we haven't received any response on this. We only received response from the ombudsman, who said that they will be checking this matter and they will come back to us, and also by the commissioner for the protection of the rights of the kids, who trying to reassure us that she's watching everything and she will be dealing with this in a way that the kids would not be influenced. But she was not of the opinion that these mandatory restrictions will have an effect on the kids at the same time. So having this response and also not having any response from the Ministry of Health on this, we were forced to actually proceed with a legal action for infringement, to answer your question, for infringement of the human rights, Article 7 for the human body integrity, and also Article 20 for the right of education, under the Section 172 of the Constitution, because we are entitled to proceed against the government and government officers in case they're doing any wrong acts or they're negligent. And also we base our action on negligence also. But because this takes some time to have a fully fledged trial with witnesses and everything, we file also an application requesting an interim order, the so-called interim order, an injunction, some people know it as an injunction, preventing the Minister of Health and the government or the Minister of Education for imposing these mandatory measures, forcing the kids to have a weekly rapid test and wearing masks 8 hours a day when they're doing their lessons.
So this can be decided faster, and if the court decides so-called interim order, they will stop checking children in school until the court decides whether it's wrong or right, correct?
Yes, if we succeed in this, then the court will issue a court order providing that it's not allowed for the Minister of Health or anybody to impose these measures. And therefore, the people who are the plaintiffs in the case, the applicants, will have a court order in their hands, which they can show when people trying to ask them to show either rapid test or to insist in wearing their mask. And this court order, it has a note that anybody who infringes this court order, it amounts to a criminal offense. They can be arrested because it is a contempt of court. So it would be
interesting, Yiannos. I want to clarify. Now you mentioned masks. So your case is in court, and if everything goes right, the court may have this interim order. But your case is to protect children and to have this in spite of this, if they decide the masks will be also decided frozen and illegal for the time of the court case.
We're asking for both.
Both.
It doesn't mean the court will give for both, but we're asking for both measures. But the thing, what is interesting though, is that both measures, they're usually taken by one order, by one decree. And and this decree, as we say, it's unlawful. For the purpose of the interim order, though, the judge might decide, because this is a temporary order and is given until the matter is tried in substance. That is, meaning to have a fully fledged trial with witnesses, and this will take time. It's an exceptional measure, the court order, and is given when you can only show, you don't need to show that you will win your case. You can show that you have a good case, just a good case. And then you must convince the judge that if it's not given, it will be difficult or impossible at a later stage, if you win, to get your remedy and for justice to be administered properly. In this case, we say there are very serious issues here because it's influencing continuously the mental state of the children who are vulnerable. It creates discrimination. It's unlawful, so it could also amount to a public policy not to allow to allow a so clearly unlawful decree to be in force until you decide whether the plaintiffs are correct or not. It's better to stay this and wait so you avoid unnecessary damage and inconvenience on these kids. And this we're not saying because we're irresponsible. I must emphasize that this is based on also scientific evidence. And we attach in our legal action, in our application for the interim order, a report from an expert which explains that these measures, apart from being unlawful, of course, and unconstitutional, they are disproportionate. It's important to tell you that according to the research that this expert did by using data from the Ministry of Health, it came to the conclusion that out of all those tests they were doing, the rapid test, every 10,000, they were only finding 9 positive. So it was a rate of 0.0009. He explained to us, and he explains in his report, that when you do tests on asymptomatic children in a massive way, there is a huge rate of false positives. It's just statistically proven this, because if you do it, this is if you do it on asymptomatic people. And in this case, he's also estimating that although it's very low anyway, the rate, imagine if you also reduce it by 40 or 50%. It's actually, and also the other important thing is that the fatality or the rate of death in these ages, it's zero. It's zero, especially from 1 to 29 years old. And also he explains in the same report, according to research that it was done and it has been published also in the page of WHO by Dr. John Ioannidis from Stanford University. The rate of death from the ages of 1 until 70, it's 0.005.
From 0 to 17 to the young, or 70, 70 or 17?
70. Yeah,
Oh,
yes.
wow.
Yes,
Okay.
and although for the flu, it is 0.01, which is actually bigger, the numbers, than the COVID. Remember, he says 0.005 for COVID and 0.01 for flu. Yes. So, and also because he says the risk of transmitting the disease these ages, because from the children, it's proven that they don't transmit to the adults so often, and if they do transmit, it's not a serious one, the transmission.
This is an interesting report, and especially with numbers and with the fact that we have 0 deaths from 0 to 29 years old. This is also important. This can prove what you mentioned before, unproportional, that the measures are too severe for the danger that these children represent to the community.
Yes, because you need to always do a risk assessment in anything you do. And this is what we say, that our government never did a risk assessment. They should do a risk assessment and balance the bad effect from the COVID, but at the same time, the bad effect from taking measures. And they should see the magnitude of the risk and take measures that are proportionate to what they're trying to achieve. And also they must take measures that they serve their purpose. If they don't serve their purpose, then you're doing nothing. You're only creating convenience. And this is very important to do, because in this particular case of COVID, what is happening, and everybody admits this, is that in an effort to protect people's health, because they consider the COVID as a threat, they take actions that they are infringing fundamental human rights. Now,
can you mention what rights are influenced by these decisions? A right of movement, we know it. A right of
even right of speech sometimes now, I would say, is it's a right of movement, right to protest, right of education, right of body, corporeal integrity, like a body integrity. And then we have even the right, believe it or not, to go have access to justice. Yeah, because the way the restrictions on the law firms of how many people will have there, then they will close in the courts. One could argue also that they even touching this human right. And it's good for the people to know that some human rights, they can be restricted, but some others cannot be restricted. For example, the right to make contracts, the right to have access to court, the right of the personal integrity, the body integrity or corporal integrity, as is stated in the Constitution. They are not subject to restrictions. But the rights like the right of education, right of movement, and rights like of this nature, of a right to protest, they can be subject to restrictions, provided this is done by law. That's what the Constitution says. And that's why our legislation, as I explained earlier when we started the conversation, is providing that any regulations, they must pass through the House of Representatives. The constitutional articles that they provide for these human rights who can be restricted, they say that they can be restricted by law for public health purposes and other purposes. But this is not enough. When they say it can be restricted, it should not go to the root of the right. It should be just limiting the right, and these limitations should be proportionate, as we explained earlier, to the danger. This is what they don't seem to understand. If they did a proper evaluation and risk assessment, they will probably come to the conclusion that a lot of the measures are not necessary. And something I always say is that there is one of the biggest massive declarations, is called Great Barrington Declaration, who has been signed by over 14,000 scientists and over 50,000 doctors, and it's on the internet. And these people, and also there are a lot of other people, ordinary people signed it, over 750,000. But in this declaration, they support the idea that we should follow the focus protection. So there is a solution expressed by scientists massively. These people are from a very good background. They are like from Harvard universities, Oxford University. If you enter, you can see their names and qualifications.
And what does it mean, this type of focused protection?
Okay, focus protection, they mean they don't agree with the measures taken so far with lockdowns and those mandatory measures that are infringing human rights and they're extended to the whole population. They believe that this matter should be dealt with by putting in place rules that are focusing on the elderly people over the age of 70 or even more, and the vulnerable people that they are suffering either from kidney disease or diabetics or other ones that may be different ages, but they consider vulnerable, maybe having thalassemia. This is the opinion, and is the only paper existing that has been signed by such a large number of scientists and doctors. Because I'm doing medical malpractice cases and I had to bring cases in court and support them with scientific evidence, usually look in the medical databases, and there is kind of categories of how important is one paper, if it's written just by one doctor, if it's written by 5 doctors, or if it's written and is amount to a consensus by maybe 50 or 60 doctors or 100 doctors. I never seen any paper that is being signed by over 14,000 people, scientists, and over 50,000 doctors. And there is no equivalent which suggests the opposite. So there is no something analogous to the Great Barrington Declaration, which has been signed by so many doctors, suggesting that the people who signed the Great Barrington Declaration, they are not correct.
Okay, so the name of declaration, can I repeat it? Great Barrington.
Great Barrington.
Barrington. Okay,
Yeah.
so thank you, Yana, for this. And now it's a time to come for questions. The questions are simple, and we need simple answers. Question number one: what about those people who live in Cyprus permanently and have been vaccinated by Sputnik V, for example? Because now everything in the safe pass, you enter the vaccination of vaccines that are in Cyprus. What about legal residents that have other vaccines? I can say Chinese people might be vaccinated by Chinese vaccine, Indian people by Indian vaccine, Russian people by Russian vaccine. What about these people? What our government says? What's your opinion?
Okay, first of all, with the vaccines, it's another issue now, because let's start from the beginning, because now everybody, according to the recent regulations, there is obligation for people either to show that they have a vaccine or a rapid test, or that they had the virus the last 6 months, and the so-called safe pass. This has triggered, again, a lot of reaction, massive reaction, and that's why now we are preparing, our office now is preparing another legal action now. Over 100 people came to us in order to proceed with that. It's important to understand, which is also relevant to your question. I will come to that. First of all, the legalities of the requirement of having the vaccine as by force or indirect force. First of all, they should never be mandatory, this requirement. Also, it should never be mandatory to do a rapid test and a requirement to go to visit the restaurants every 72 hours. This is infringing badly the human rights, as we said before, and is disproportionate, clearly disproportionate. Also, it's against apart from the Constitution, it's against the Treaty for the Protection of Human Rights and Human Dignity for matters relating to biomedicine, which has become also law in Cyprus. For example, in this treaty, there is a general provision, Article 5, which says that any medical treatments which would be done on any people, any humans, you should get their informed, free consent. And also Article 16 of the same convention, treaty, it provides that if anything is under experimental stage, then again, you should get the informed consent, free informed consent, as provided by Section 5. And these provisions, I mean, the provision about the experiment, it cannot be restricted for reasons of public health. Article 26 of the same convention, it provides that Article 16 is not one of the articles that it can be restricted even for reasons of public health. As I know that some people have the impression that these vaccines are not at an experimental stage, but I don't really agree. When I read in different papers, medical papers, you can clearly see that all of these vaccines, they have they are left a few years still that they carry on trials on people, and they say that. They're trying to excuse that and say, yes, but because we pass phase 3, for example, and because it seems like it's relatively safe and blah, blah, they use their scientific language. Those who want to support that they are not in experimental stage, trying to convince people, they say, no, it's been approved to circulate, but it is approved temporarily and for emergencies anyway. So I have my views on this, and also some scientists say that they are still at the experimental stage, and they shouldn't be allowed to be used for everybody. Maybe for exceptional cases, for emergency purposes, and for the elderly and vulnerable, maybe. Yes, but not for everybody. Of course, anybody who wants to do it, they could do it as long as they have been informed properly about the real situation.
Yeah, and I want to stop you right here and to say that today we published in the news, we translated from Greek into Russian, the fact that children will be vaccinated, that Cyprus will accept and admit the fact that there is a vaccine for children of 12 to 15 years old. Now, what's happening here? We received few letters from our readers. For example, a case in Paphos. A lady works in a Paphos hotel, and she received an email from her employer that only those employees who've been vaccinated can come back to work. And she was shocked because this is only means she lives with this money. She cannot survive without the salary. So she was shocked that she cannot come back to work. Now, if the vaccine will be introduced to children, that might be the same situation when the schoolmaster will say that, okay, from September, only vaccinated children can have access to education. Can it happen, and how to fight against this?
Okay, this is something that if the government does not really accept this position that this is unlawful and it shouldn't be done, unfortunately, the only way to deal with these things is to ask for help from the court, hoping that the court will follow the law in this case, and after examining all the circumstances. For the reasons I explained earlier, what's the point of forcing kids to have the vaccination when the fatality of the kids is zero? And also, why should we force kids to have a vaccination that hasn't been yet finished its whole circle for approval? I know that
this court case, sorry, this court case, we know how lengthy are the court cases in Cyprus. What do you expect? What is the best scenario? How soon you can get this interim order if everything goes well? And what is a realistic scenario? What might be, let's say, how many months it might take for your first case to go into the phase where you will feel some results?
Okay, as I said, now hoping that we will achieve this quickly through the court order. You know, if we achieve to get the court order for the children case, it's just limited what we are asking for the rapid test and the masks. But now we're filing a new legal action relating to the safe pass, and we are raising there the issue of mandatory or that is unlawful to force directly or indirectly people to do vaccination. If it comes to if the court gives a positive judgment and gives this order, this will be relatively coming out very soon. Even if it's not done, I don't know, because now we need to file the legal action. But usually, as you have seen from the other case, although the lawyers from the Attorney General office, they ask for time to put their opposition in that case, they give them less time than they were requesting. And although it was filed before Easter, now it's already on the 17th for hearing. Of course, it doesn't mean that they will not try to ask for another adjournment, but this kind of adjournments, they cannot be long. It has to be soon, and I can object, and the judge might not give them the. So when we speak about the court order, it's relatively very quickly that it can be done.
So on the 17th of May, you have the hearing, and if everything goes well, we can expect that maybe in May or June, they may issue this court order.
Yes, but that will be, but it's going to be a sign, a good sign, because although it will be for the rapid test and the mask, it will be an encouragement for any other legal actions. And if we need to do a specific action just for the vaccines on the children, when this, if this ever happens, then we will know that at least we have already precedents that show that it can be achieved. But you know, what we are saying, it coincides also with Council of Europe. The Council of Europe in, we'll see, it was the beginning of the year. They said that in their decision, 27th of the 1st, 2021, they said that the vaccination is not mandatory. Nobody is forced politically or socially or with any other way to be vaccinated if he doesn't wish to be vaccinated, and that is not allowed to make any discrimination for people who don't accept to do the vaccination. And it says that also the rule about proportionality must always be followed. This is what the European Council, said, actually.
I have only 10 minutes to get from you answers to our questions. We have a big list. So Sputnik, if somebody is already vaccinated by Sputnik, how you think, what is your advice, what to do with this? He or she cannot have safe pass. He or she, being in Cyprus, still need to go through rapid tests for the time being.
Okay, this is like discriminating between people who did one vaccination and another vaccination, and it creates inconvenience, and also it's unlawful, and especially when they are Cypriot citizens, these people or residents here, they should be treated equally with the other people, and I don't think it's right to when a country which is in the international, which is a proper country in the United Nations approves something for their people, and they use it for protection, that another country should not accept it. And what is the reason for not accepting it?
Yeah, and it's also a contradiction, because we in Cyprus accept tourists with Sputnik V, and we don't ask them for any test, so they can go anywhere without anything. But while we speak about local residents with the same vaccine, we restrict their movement.
Yeah, I believe this is clearly again unlawful, and is a discriminatory thing, and is not justified. It's not justified. From the moment you have a rule that you accept the vaccinated people, why are you choosing a different brands and not another one, when all of them, more or less, they have the same features and the same problems?
Okay, we finished with this question. Next question. What law does police apply for fines? We're not going to answer long on this question. I will read all 4 questions regarding fines. So, according to what law police acts when they issue a fine? What should I pay this fine, or what happened to me if I will not pay the fine which I've got? And the question is in the same set. Can I record the police officer what he's saying to me during this interaction when I argue with him regarding the fines? So 3 questions. Everyone, everything about the fines.
Yeah, first of all, they base their fines on what the law I said at the beginning of this conversation is the infectious disease law. And in there is there's a section which have been also amended, which provides gives some powers to the police to enter to shops and business to check, and to also fine and to fine also if there is the so-called infringement of the law.
Okay, so a person didn't wear a mask, it was wearing like this, or a person did something he does not agree with the fine. If he does not pay, what will happen?
If it doesn't pay, then it's like the traffic offenses. They will, at some point, usually it takes ages to do that, they will bring an action against him, a criminal action, with this blue form, which they will invite you to go to court. And the same as in traffic offenses, sometimes you say, I plead guilty. If you want to dispute it, then you say not guilty, and then there is a hearing, and there the prosecution has to prove whether you committed an offense or not. Mm-hmm. And in this case, is what I said again at the beginning, is that from what I believe as a lawyer, from the moment that the decree that has been issued according to this infectious disease law, Article 6, is not lawful because it hasn't gone through, the measures have not gone through the House of Representatives to approve them, it means that this kind of action is destined to fail. And in fact, tomorrow we have a case that I'm going to be going to court to defend this lady that she didn't wear her mask. And I will raise this issue before even she is invited to plead guilty or not. I will say that this action has to be dismissed because it is an abuse of the process of the court. It's unlawful, the indictment, the charge, and as a matter of public policy and in order to safeguard the rule of law, and it is clearly unlawful, this decree, then this case should be dismissed. I don't know whether this will
so even tomorrow we'll know how they react on this position.
Yes, if they do the case tomorrow and they don't want to adjourn it, yes. I know another case that some colleague of mine trying to raise it in court. Of course, the result was good, but because it was about the protest, that it wasn't about the mask. And when he's trying to raise these issues, the prosecution decided to withdraw the case. And so they has been not found guilty, but it wasn't through a judgment. It was because the prosecution, for some reason, as a tactic, I don't know, they didn't want to risk it to make a judgment. They withdrew their case.
Okay, all right. So I have 5 minutes with the remaining question. So a list of laws we are not going to do for this.
You said also about the recording also.
Yes, recording, yes.
Yes, the recording, it's okay. This is public and you can see, you can record, and also it's a kind of protection of your human rights. And the policeman sees that you're recording him, that you're videoing him, they cannot do anything to you.
You have right to record, have you?
You have a right. You can see a lot of people do that, and the police cannot really stop them from doing it.
It's important. The police cannot stop you from doing it. Now, yes, in one of the questions, they attached also a kind of a letter that was in the Facebook now recently, a few days already, that the police officer which is trying to fine you for something should sign something. I don't think they will sign, but we wanted to know your opinion. What is this paper circulating everywhere?
Okay, I don't know. It's an effort of doing something from some people, but personally, I don't think that it helps at all, because I don't think that anybody would sign that. It's not obliged to sign it. And it could only create unpleasant moment and aggression and firing discussions with you and the policeman. And it will not really, at the end of the day, serve you any purpose, this thing, in my opinion. The best thing to do is, if you have to be cool about this thing. You don't need to argue with anybody. You don't need to put yourself into more trouble. And you don't need to lose your patience and shout and all these things and be abusive. The best thing is to, if a policeman wants to fine you, just let them fine you. They will fine you. Whatever you do, they will fine you. If you are polite, sometimes they might not fine you if there's a good policeman. But if you're aggressive at everything, or you're trying to make them sign things or accusing them, the result would be that they will fine you, but also they could even fine you for other things. So please, it's better to ignore them, let them do whatever they're going to do. And if you don't want to pay because you think that this is not correct and it's against the law, then you wait until they prosecute you, if they ever prosecute you, in order to defend yourself if you wish to do so.
I see. All right. And the last question, because I have only 2 minutes. The last question will be regarding the court case that you're preparing. We have questions here. I read them in the chat. I have questions in my papers. How people can join this new court case that you will have against vaccination, safe pass, and all the situation where we are now. You said it's about 100 people who are ready to file the case, and you are trying to file it as soon as possible. So we can also have an interim order regarding the forced vaccination or forced situation with tests.
Yeah, first of all, I would like to clarify that any person is free to choose their own lawyer. I'm not here to attract any people to come to me. I mean, there are a lot of good lawyers around, and it's not just me. If anybody wants to take an action, they can do it with a lawyer of their choice. As far as we are concerned, and our office is now preparing to have a legal action, because a lot of people express interest and they send us an email asking us whether they can proceed with a legal action and join a group of people to do that. If you want to join any group of people that they're doing a legal action, the thing is to communicate with the lawyers that they're doing this legal action, and then to express your will to do so, and then you need to assign authorization and retainer, which authorizes lawyers to proceed further.
Mm-hmm. And if if you apply in a group of people, so the expenses are shared, I believe. Can you tell us approximately, at least, how much does it cost to apply as a group, per person, per family?
Because our intention was really to help in this case, and we're doing this at the expense of the rest of the work of our office. It's not a case we consider ever to be business. This is just because I strongly believe as a person myself that this is not correct what is happening. And since that I wanted the people to know the truth and take their own decisions. When I proceeded with this, also with the first time with the parents, and I wanted the people to feel comfortable about this. And that's why we didn't proceed with a different separate legal actions, because that would be very expensive for every person. So we proceeded with this because all the people have the same interest, same course of action. And therefore, because it's a lot of people, and also I wanted people to be feeling safe, that they have certainty of their cost on this in order to make an informed decision as to whether they will proceed or not. We committed ourselves as an office that each person will be bearing a cost of 250 euros plus VAT, and that will be the whole cost they have for legal fees, no matter how much time we spend and when this case will finish in the district court.
So in a way, your company takes responsibility. If it will be longer, you're not going to charge them more. So in order to file the case, in order to be a part of this group, they need to share the cost, and each one will pay 250 euro, and that's it. No surprises on a later stage.
No. The only other cost they will have is when we use an expert witness to give evidence in court and make a report. And if this person charged, some of them might not charge. Some people they're willing to, because to help. But if they do want to charge, that would not be a huge amount to share among 100 or 110 people. If, for example, an expert witness charges 2,000 or 1,500 for his services to provide evidence, you can understand that this is not a huge cost if you share it with all the people that are in the case. So we're not talking about huge costs. It's not a big exposure of every person to participate in a legal action. When there are a lot of people, it has also a lot of dynamics, and it gives messages more. And I always consider this kind of actions as a kind of a protest, not just a normal action. It's just usually it's people who are fed up with this. They're people who are expressing their disagreement in a legal way through
and
the
who cannot sit still and watch how the situation is happening. So they want to do at least something.
yes.
And I agree with you. It's a way to protest because they're not winning much out of this case. But if they can stop, if they can get at least an interim order that will be for public health, will be for everyone.
It has already shown that it has awakened a lot of people, that the fact that we it's a bit by bit. When I did first, when I did publish an article on these issues, nobody was talking openly, and even some people were trying to, people even close to me, trying to discourage me from doing that, just in case that something negative will happen to me, to my career, to my profession, to, you know, all these things, which I ignore, of course, because I don't believe that or as a people should think in this way. If we think in this way, it means that we deserve what we get. If we always worrying and have fear, and we're trying
to
to
voice our opinion, to put our position known to other people.
Yes, I think that we should not think our personal interests and consequences in case we raise our voice against the authorities or against something that we think is improper. And also, being a lawyer is even more the duty to be straight and not nothing to stop you to go even against the government or anybody, any institution or who is violating human rights and is not proper with the ordinary people.
I see. Yana, we have to finish. We already are over our limits, but I want you to make a kind of final statements, maybe 5-10 sentences to summarize everything which said or which was not said during our today's meeting. Yes.
Okay. Today we're facing with this so-called pandemic that, of course, we acknowledge the fact that we have this fatal at some time and for some people virus. But on the other hand, we need to be sure that we don't really use this as an excuse to violate our essential human rights that we built through the years with a lot of struggles. A lot of people have died in order for us to be here and have a democracy. And we should not allow a crisis of this nature to destroy what we have built all these years with a lot of fights. It's a respect to all the people who fight and with their life in order for us to have a beautiful life today. So we need to really balance everything in a normal way. What happens now is extreme because they have not really made any risk assessment. They have not considered the collateral damage. People are rushing in governments to impose unlawful regulations and mandatory rules violating your human rights. And then this, it seems like at the end of the day, our only hope is to either by protesting, but also by using justice, by going to the court and demanding from the court to examine the case and make a decision on our human rights. And in order to avoid all these bad things that are happening to so many people, the suffering and the children that they're restricted from their education, the people who are closing their business, the families that destroy, the people who commit suicides. This has been ignored completely. And the media, they also damage a lot the whole situation. They didn't help because they spread fear. They spread fear to people, and people, when you're spreading fear, then it's easy to manipulate people. So we should not give up. We should not really give in fear, because we should have a faith and belief and use our common sense.
All right. Thank you for this. And with this statement, I will stop recording. Thank you for today's meeting.